All right, today we're reading for bedtime from the American Story, 1954, Brown versus the Board of Education. When Linda Brown was 8 years old, she had to walk a mile through a dangerous rail yard to get to her elementary school, a mile to school and another mile back home. There was another public elementary school just a few blocks from her house, but when her father tried to sign her up there, he was told no. In Topeka, Kansas, the schools were segregated. Segregated means white kids and kids that were black wouldn't go to the same school. The school near Linda Brown's house was for white children. Linda was black. Oliver Brown decided to sue the school board of the city of Topeka for the right to send his daughter to the white school. He lost. But he decided to go to a higher court. Soon his case came to the attention of the National Association for the Advancement of Colored People, NAACP. The legal team was looking for cases to argue in the Supreme Court of the United States, cases to challenge racism and segregation. Already the NAACP team and its fiery head attorney, Thurgood Marshall, had assembled a group of cases about school segregation. They decided to take 5 cases at once to the Supreme Court, and these cases were known together as Brown versus the Board of Education. Years earlier, the country's highest court had decided that as long as facilities and opportunities were equal, there could be separate schools for white and black children. But when the court opened to hear Brown versus Board of Education in December of 1952, Thurgood Marshall argued that racial separation deprived black children of equal status in the school community, destroying their self-respect. The burden of being separated did actually damage and shouted inferior to black children. Any system that separated children according to race was by its nature unequal. The 9 justices of the Supreme Court grilled Marshall. Would he object to separation on any basis? On the basis of intelligence or skills? Would the school set aside for blue-eyed children be unfair? Thurgood Marshall answered without hesitation, "No, sir, because the blue-eyed people in the United States never had the badge of slavery," which separation echoes. After hearing both sides of the argument, the court retired for several months to consider its decision. It took them months. But when the court opened session again in June of 1953, the nation's highest judges had no decision. Instead, they asked Marshall and the NAACP to prepare answers to 5 legal questions about school segregation and the U.S. Constitution. These answers would help the justices interpret 200 years of American law and make a ruling. While the NAACP team was at work on the questions, though the Chief Justice of the Supreme Court died, suddenly everything was in doubt. Would the NAACP have to re-argue the case? Who would the new Chief Justice be? Would the new Chief Justice be with them or against them? Just 5 days before the Supreme Court's term was scheduled to begin, President Eisenhower named Earl Warren, the former governor of California, to be the new Chief Justice. Thurgood Marshall and the NAACP team argued their case all over again, and again the court retired to consider its decision. It would have an answer on Brown versus Board of Education by spring. They needed more months. The weight was hard on the nation. There was hardly a person in the country who wasn't aware that the decision would be the most important civil rights event since Lincoln ended slavery. Marshall toured the country, speaking to large audiences to raise money for the NAACP Legal Defense Fund. Meanwhile, Chief Justice Earl Warren decided to do some sightseeing. Being a native Californian, he had lived most of his life far from the echoes of Southern slavery. He and his black chauffeur set off to tour the Civil War battlefields of Virginia. At the end of a long day, Justice Warren decided to spend the night in a country hotel. When he came out in the morning, he was shocked to find that his driver had slept in the car. "What's the meaning of this?" he wanted to know. "Well, Mr. Chief Justice," the driver explained, "I just couldn't find a place." The California judge met segregation face to face. His driver hadn't been allowed to spend the night in that hotel or any other hotel in Virginia. Hotels in Virginia did not cater to black visitors. "I was embarrassed. I was ashamed," Warren wrote years later. When he returned to his office, it was to do everything in his power to secure a unanimous decision. He wanted every single judge to rule in favor of desegregation. He wanted not a shed of disagreement to linger in the air. The court was packed. Every person in the audience strained forward to hear the verdict. At last, the Chief Justice announced their decision. "We conclude that the field of public education, the doctrine of separate but equal, has no place. Separate educational facilities are inherently unequal." The ruling was unanimous. Note, Thurgood Marshall himself was appointed to the Supreme Court in 1962. What an interesting story.